In addition to not being a philosopher, logician, theologian, gay, and a long list of other things Christian apologist William Lane Craig is not, Craig is not a constitutional scholar. In the July 5th, 2010 edition of Dr. Craig's Current Events audio blog, Craig talks about the Supreme Court's recent decision in Christian Legal Society v. Martinez. I did a video on this decision, link in the description box below. Craig serves up a harangue brimming with alarmist and inaccurate claims about how the CLS decision
significantly sets back the freedom of assembly, freedom of speech, and freedom of religious expression in this country.
Of course, the decision does none of this, quite the opposite, actually. As is often the case, Craig combines ignorance and a penchant for propaganda here. Among the ways one can know this is by Craig's frequent use of the buzzword strict constructionist, and his suggestion that the 4 dissenting justices in Christian Legal Society v. Martinez, including Antonin Scalia, are strict constructionists, and as such, just what the court and the country need more of.
And this just underlines the importance, I think, of scrutinizing very carefully, not simply the proposed appointments to the court made by various presidents, but also scrutinizing the views of the presidential candidates themselves to make sure that they will really vet these candidates for the court and will appoint people who will be strict constitutional constructionists.
If Craig knew what he was talking about, then he would know, for example, that Antonin Scalia unequivocally rejects the label strict constructionist. In a 1995 lecture delivered at Princeton University, Scalia said, quote, "I am not a strict constructionist, and no one ought to be." Oops. Scalia called strict constructionism a, quote, "degraded form of constitutional interpretation." Oops. Scalia said, quote, "A text should not be construed strictly, and it should not be construed leniently. It should be construed reasonably to contain all that it fairly means." Oops. Constitutional scholars know, as Craig does not, that the term strict constructionism is more political than jurisprudential. As constitutional scholar Cass Sunstein of the University of Chicago says, quote, "Strict constructionism promises a general theory of interpretation, and it isn't able to fulfill that promise." Constitutional scholar Lawrence Solom of the University of Illinois says, quote, "Strict constructionism isn't particularly descriptive, and most serious constitutional theorists avoid using the phrase." What sort of people do not avoid using the term strict constructionist?
I believe in strict constructionists.
Craig also calls for judges to be literalists when it comes to the Constitution.
Appoint people who will be strict constitutional constructionists and who will adhere to the letter of the Constitution.
If judges were to heed Craig's call to constitutional literalism, the First Amendment's protection of
such important rights as the freedom of assembly, the freedom of speech, and the freedom of expression of religion
would not apply to the University of California's Hastings College of the Law or any other state institution, because the letter of the First Amendment makes it applicable only to the federal government. The state of California or the public law school could ban Christian Legal Society or even Christianity itself if Craig's constitutional literalism obtained. In sum, William Lane Craig doesn't know what he's talking about here. He's not a constitutional scholar. He's just making stuff up as he goes along.